G'day Kim, how are you?
I'm good, Andrew.
God, it's a different person every week, isn't it?
I know. Well, our team's growing, so that's been really good.
Well, that's been exciting, hasn't it? Yeah. Now, look, can I raise a couple of things? We've got a new bit of Victorian legislation on labour hire. Not legislation.
A bill.
Yeah, it's a bill. It's out there. It's second reading time. But interesting because of the nature of criminal behaviour, particularly influencing the construction industry. This is a change of the legislation to prevent criminal organisations being involved, but also to protect people who put their hand up and say something's wrong.
Yeah.
I can't see that having too many troubles getting through, can you? But when it does come through, we'll give you a bit more detail, but it does show that Australia is now dealing with highly organised crime in all areas. And in our workplace law, we're starting to concentrate on it, and particularly the building industry, where it's been prevalent forever and a day.
Well, this is focusing on labour hire, the bill, isn't it?
Yeah, it is. All right, look, the other thing that is a case, and John Darcy, mate, reach out to you and thank you for a new case where it's ACB Group who's facing a number of charges about the death in a workplace where blending flammable fluids exploded and killed someone, but the general manager has been charged under Section 144, which is the officer duty. Be interesting to... It's not the issue that John has raised with me with the case, but interesting to see whether this general manager really meets the officer threshold, because it's not an executive member, it's not a director, and whether they have the capacity to have introduced and influenced the need for a system. I'm not sure. But let's watch this space with this case, whether that defence is raised.
Okay.
So they're just a couple of things to start off before we get going. Kim, the first case we're talking about today is Demetropolis, okay, which is, I did, didn't I, which is a redundancy case. Can you tell me a bit about the facts?
Yeah, so Federal Circuit Court, so it didn't settle at the Fair Work Commission. So we've had the joy of hearing from our old friend Kath Simons, who we used to work with very closely.
Yeah, which is...
But anyway, this employee was awarded $35,000 for the company breaching two clauses of their enterprise agreement for failing to consult with him in relation to his redundancy. But prior to that, withholding key information from him which allowed him to do his job. So he claimed that he was bullied by the CEO and COO. Yes,
and this is a really nice case, isn't it? Because the proper remedy was actually reinstatement, but they paid the $35,000 because it's not going to work. And it just goes back to that issue around when we look at redundancy, you can't just tell someone. You can't just say, oh, well, now we're going to do it. Yeah. And they'd withheld information from him. So they'd been withdrawing duties as they went along and then said, oh, and by the way, you're now redundant. So by the time they got to the redundancy, they'd actually taken the duties from him. So really unhelpful and destructive behaviour. And that type of thing commonly happens in redundancies where you start going, I'm not sure we'll need Kim, let's just grab a couple of jobs. Well, when you do that, you're effectively repudiating the contract in any event. So I thought a really interesting case, and it was great to see Judge Simons at work. The next case to me is Bowler and Uniwater, which is the secret recording case, Kim.
Yeah.
And I've put this case in, and I put this case in because sometimes there's a narrative that exists in an organisation that someone has done something wrong and then everyone goes and constructs it afterwards. So
that's exactly what happened.
Talk to me more about the facts on it.
So we've got first thing to note, we've got a 23-year duration employee with an unblemished record.
That's workplace talk, unblemished record. I don't know why we say that. It's true, he does have an unblemished record.
He made some unfortunate comments to a young woman who was in her probation, but she got promoted and it was a job that he went for. So there's no doubt that he made some regrettable and unprofessional comments, but there was an internal investigation by the HR manager. She listened to a recording that was recorded by the young woman, but took snippets of it and used bits of it to bolster the allegations, which the court held were very confused, lacked particularity, and didn't afford him any procedural fairness.
And didn't reflect the content, ultimately, of the recordings.
Right. Yeah. So, as they said, while he acted unprofessionally and it was in breach of the Code of Conduct, it wasn't sufficient to terminate his employment.
And again, in investigations, can we just go back to what investigations do? 4 stages of an investigation. You identify who is a complainant or is the organisation doing it, that there is some breach that is alleged to occur. Step 1. Step 2, you create a letter of allegations based from the complainant, which are factual, which identify time, place, person and action. Step 3, you make sure you put those exact things and disclose during the time of that all relevant evidence that pertains to those allegations, not hiding or selecting what you do.
Yeah.
And 4, after you make the findings, the person then has a show cause in respect to the findings that we make.
Yeah.
And at every stage of this, it has failed.
Yeah.
And when you do that, even if it's a common law employee, the High Court's decision of Kiora basically says that you must afford someone natural justice in any disciplinary process. That requires those 4 steps to be met, just like it does, but it's more rigorous and unfair dismissal.
Yeah.
Okay? So if you can remember that about investigations, you'll be a lot better off.
And he was reinstated.
He's reinstated, so please don't prejudge. Don't jump the gun and try and stitch someone up. Can I just tell you how much I love the Fair Work Commission anti-bullying regime? You and I both work in workers' compensation, where reasonable management action is a tarnished concept. Okay, but it is a robust jurisdiction, isn't it? The Fair Work Commission, and in this case, this was about a manager who, when managing someone, realised there needed to be alterations in contracts, had some very direct conversations with them, and the person said, that ain't reasonable management action. You can probably give better facts. I'm inclined to gloss over things, I know.
Well, I was hoping you'd talk about this, because I don't want to swear at this one, because I think this employee was incredibly difficult, and the manager had a really difficult job to navigate him, and did a very good job in doing so. And he had a very skewed idea of how he was being treated. And it astounds me that some people like him would bring an application like this when it clearly he was just being reasonably managed by his manager throughout.
But I guess in workers' compensation, in Victoria, prior to the changes in the legislation and the change in government policy that drives that, this would have failed on reasonable management action. It would have failed in reasonable management action every state and territory besides Victoria at the moment, maybe not Queensland, but every other one. And what I want to show is that the law does prevail in the Fair Work Commission, but policy prevails in workers' compensation, and
it's not consistently applied.
No, and it's galling, isn't it? But you're right. As I read the facts in this case, I thought, thank God this isn't the workers' comp jurisdiction. Thank God this is in front of the Fair Work Commission, where industrial reality lives and where you're allowed to be robust, where you're meant to be direct in your relationships. So look, good case, fun to read. Right? That's probably not the best reason to do it. Kim, before we started, we were talking about this parental leave case, which is Hong in 2022 trading. Interesting case, okay, because it mixes, it's a bit like Ghostbusters are mixing the stream. So it mixes redundancy along with the common law of redundancy, along with termination. So in simple terms, a woman's role while she was on parental leave was being changed. She didn't think she was being treated fairly, so she brought a general protections application as an employee, not dismissed. They responded by saying, well, the job doesn't need to be done, and she then withdrew her general protections application as an employee and recommenced a new one, which is terminated. And they said, but wait a second, we haven't terminated you yet. We've offered you suitable alternative employment. Who knows where we ended up, but what absolutely is true, if I say your job no longer requires I am terminating your employment, the concept around redundancy, that as it sits within the Fair Work Act only, says, well, if you offer a suitable, reasonable alternative employment and you've exhausted opportunities, then that still makes it a genuine redundancy, but it doesn't change at contract that you have terminated someone's employment.
Okay.
And so we've got a bit of a crossover in the language that is used, because the Fair Work Commissioner has said, well, no, you've repudiated the contract and therefore that it is a termination. I'm not sure this is the world's greatest decision, but it's interesting when you look at what the two different pieces of law that exist. One is award-based and says it's a genuine redundancy. You have a genuine redundancy if you've said the job no longer requires and you've offered suitable alternative employment. Good, genuine redundancy. If you don't offer suitable alternative employment, then it is termination per se, and therefore it is repudiatory. But you've got to always remember there are these two different bits of law that run side by side, and for the purpose of, was employment terminated? I don't think this case is a good case. But at common law it would be. Okay? So I only put it in there just to show what that difference is, and we don't know enough of the facts to know whether there was suitable alternative employment. But whatever it is, interesting case, because we do start fiddling and realise that the law is not easy when the two different jurisdictions of common law and statutory law apply.
And the other thing about this case, just going back to the other one we talked about, is the importance of consultation with redundancy, and I think that really let the employer down in this case as well.
Yeah, that's true. I think this was my heading when the chickens come home to roost. I think about 4 or 5 episodes ago,
we talked about this.
We talked about a case where a person was alleged to have wrongly counted their chickens for the benefit of obtaining something like $8 or whatever. I can't remember what it was. So it's Wen Kun Wang and Springtime Poultry is the name of the case. Went on appeal, and what they found is the original decision was based on submissions, not on evidence that was delivered. Now, can I just say, the Fair Work Commission is not an easy place, because it's very clearly not governed by the rules of evidence. And it's very common that what you submit is weighed into whether that is a fact that is an issue. But submissions alone is never evidence. Now, if it's a self-represented person who comes along and gives submissions, which is part of their evidence, that's different. But this was an organisation who made submissions but didn't lead evidence that proved the manipulation of counting to get benefit. And not surprisingly, the full bench said, wait a second, where is the evidence? So for all of us, when we're heading off to have our argument in court, for you and I, it's second nature. For you and I, the first place we go before we even look at the law is we go to the facts. And I think all our staff would find us very hard taskmasters when they come and start talking the law. We go, whoa, wait a second, I can't see the evidence for what you're talking about. So many cases get before the Fair Work Commission where people have a narrative or a view and seek to prosecute it without evidence. Before you come and see us, go to the facts. Always be sure you got the facts right. Anyway, good case. Main topic today, this is Safe Work New South Wales, and Mills is the case I want to talk about, but it is a very limited case about trenching, right? But what we've now seen is 4 or 5 safety cases that repeatedly come up and say, when you're dealing with high risk, whether it's working at heights, whether it's working in a confined space, whether it's trenching, if you don't hold the requisite skills, you must get experts to assist you, because the nature of the risk is so high
and obvious too.
And obvious that you need to know what is the correct method of control. Remember, reasonable practicability has 4 elements. Is there a hazard? Working in a trench, working in a confined space, working at heights, hazard. What is the level of risk? Based on risk of injury and frequency. Okay, what's the highest level risk you can have? Because a collapsing wall in a trench will kill you, falling off will kill you, gas in a confined space will kill you. All right, so we know it's really high risk. So what is the control? Well, we go to the hierarchy of control. We know at high levels of risk, administrative control, the bottom level of the hierarchy, is not enough. We're looking at elimination or mechanical methods that prevent that risk from materialising. If you don't know it, you've got to go externally. And that's what this case is about, isn't it? Now, you talk more about the facts, but it is alarming that something like this could happen.
Yeah, so they dug a trench for a residential build, put all the landfill next to the trench, and they didn't shore it up. Apprentice got into the trench to clear away some debris, and the landfill fell in on top of him and crushed him. Yeah, he survived.
Yeah, can I just say it's very common, because normally you do put it and you have this mound on the side of it, and the depth of the trench is from the top of the mound, not from the soil, when you look at how the regulations apply to it. So you're over 1.8 metres down at that stage, you've got a problem. But even if you're not, you do understand that you're dealing with volatile substance. In other words, recently dug up ground, which is not solid, with an unstable boundary. So you've got to put up a border to protect yourself. So again, I guess when we're talking to clients, one of the things we talk about in safety, and you'll hear Nina say it all the time, is, but isn't this a high risk? What is your expertise? If you don't have that expertise, let's get it for you, but just don't wing it.
Yeah.
And this was a case of winging it. Look, he's only in there for a second, what does it matter?
Yeah. They didn't even have swims.
No. Yeah, I know, scary. And remember, just say you're on a bad day and you didn't have to do a swims, but you still have to do some form of risk assessment. So yes, the regulations define when you do have to use swims. They're such great documents because what they articulate is from the start to the finish of the job, in the order in which you do it, what is the hazard, what is the risk, what is the control. So in an ambulatory way, as if you're walking through the project, you could go, I'm about to dig a trench. The risks in trenching are if people go inside the trench. Okay, that is a high risk. It's a hazard. The moment they get it, it's a hazard. Okay, what do I need to do to protect that? Even if no one's meant to get in it. Okay, so maybe I've got my backhoe and I've dug it out, but there is a risk that someone could get in. So I've got to prevent people from getting in it. Do you see what I mean? As you go along, the controls become very... What if someone does get in, even though we've told them not to get in? Okay, we need to make sure it doesn't collapse. If you haven't got the skills, go get them. And if you don't, you're going to end up like this case where you're going to be prosecuted as a result of it.
$225,000 later.
Yeah, and can I just say, you know, we're in the Eastern Seaboard and South Australian jurisdiction, the person who is the operating mind of that organisation, if they don't have the systems in place and aren't being satisfied the systems are being implemented, would be at high risk of personal prosecution in Victoria under 144, under Section 27 of the Model Act with the due diligence obligations. Much easier everywhere else than Victoria to be prosecuted. But in Victoria, if the owner of the business, and this was a small business, was there, saw it and didn't have it in place, they'd be prosecuted.
Well, he was.
Yeah. So look, interesting stuff. Why don't we go on to the case study?
Okay. Jan was a clerk at Nimbus Paper. She managed inward invoicing. Her boss, Cedric, was an uninspiring man who often struggled with Jan. He considered her a 30-something who was full of entitlement. One Friday, Jan attended work feeling unwell. Her lips were dry, she was sweating profusely, her pupils were dilated and she appeared confused. Cedric formed the view that she was a meth user. His son had been an addict and the symptoms were well known to him. He confronted her near the lifts where she was standing, holding her stomach and appearing obviously confused and irritable. Jan looked startled. She told Cedric to go away. She was unwell and wanted to be left alone. She said she needed to go home but urgently needed to use the bathroom before leaving. She stumbled to the bathroom, returned visibly distressed and then fled from the office. When Jan arrived at work the following Monday, she was given a letter directing her to participate in an investigation into alleged illicit drug use and intoxication at work. She was stood down on the basis that she posed a risk to herself and others. She received an allegations letter that described her physical presentation and alleged drug use and intoxication. Jan denied using drugs and complained that the process was flawed and unsafe for her to participate in. She stated that there was no support person offered, that the process lacked procedural fairness and was based on an incorrect medical conclusion and lacked direct evidence. No one asked whether she had seen a doctor, if there was anyone who could substantiate her explanation, or for further details about when or where she had eaten the food that allegedly poisoned her. As 3 witnesses observed her confused behaviour and in lay terms it was not consistent with their understanding of food poisoning, the allegation was substantiated and her employment was summarily terminated. Cedric was the decision maker. He considered her alleged drug use, rudeness toward him and complaint about the process typical of her entitled behaviour.
There you go.
Okay.
Good. I thought it was fun, wasn't it?
Yeah.
So the first question is, would the investigation offer sufficient procedural fairness under both Fair Work Act and the common law?
No.
And the answer is absolutely not.
Yeah.
We don't know what would have happened, but let me be really clear. When someone comes unwell and confused to work, and it's a risk, you do have to take them away from work. So when they're in that state, well, she fled, you're fine with that.
Yeah.
When she does come back, you'd have to be satisfied she was fit on her return to work. So you'd need at least a certificate from a doctor saying that she was fit for work.
Yeah.
Okay? Good. But when I go to investigate, I have to investigate the underlying facts. Okay, you say you've been food poisoned. When did you eat the meal? Where did you eat? And is there anybody else who can tell us about what happened afterwards? And did you go and see a doctor? Now, in food poisoning, and I've spent my life being food poisoned all around the world, I don't often see a doctor, but I have a number of people around who can tell you exactly what did happen 3 hours later. Had those inquiries been made, they'd probably support her. But what's happened is that Cedric has formed a view, a predetermined view, based on a protected attribute.
Yeah.
So he's in a lot of strife. So the answer is no, it doesn't meet cure and West at common law. There's not a procedural fairness, and it certainly doesn't meet the Fair Work Act procedural fairness requirements. And she's a clerk under the Clerks Award, so she's covered by the Fair Work.
Okay.
Was the employer's conduct a breach of safety legislation? Okay, now I want to just... She is saying, she could be saying, she's being discriminated because she raised a complaint around her safe workplace. And Cedric's own comments reveal that that is one of the determining facts that made him make the decision. So there is a risk of discrimination under safety law. I know it's not often done, and it's the safety regulator who brings that. But the other part is the behaviour that goes towards providing a safe workplace. The failure of the investigation is a breach of the obligations to provide a safe workplace. The failure to check on a health, to monitor a health on a return, all those go towards a breach. Would they be prosecuted? No. But I want to show you that those breaches are frank and can be used and leveraged off in other causes of action like discrimination law, general protections or unfair dismissal. All of those safety obligations are breaches of procedural fairness. They are breaches of her safe work environment, and her complaints form part of a safety-based complaint for general protections, which really does bring us to our next question.
I don't think a lot of people would appreciate that.
No, but if we go back to Burke and Suncorp, I mean, it is the place where we first see safety law infiltrating into a general protections claim, where they said, the obligation to monitor health is a part of employment law, and therefore the failure to do that is fundamental. So I think we are seeing, and Nina and I spoke last time, how safety is penetrating like tentacles into every part of workplace law. I just want you to know it's alive here. So did she have a claim under general protections or discrimination law? And I think unquestionably that she did. What do you reckon? That's us?
That's us.
Oh my God. See you later. See you next week. Thumbs up.
Bye.